Hello. I'd like to welcome you once again to Immigration and You, the iCanada Direct Immigration Services online weblog. Earlier today, while I was searching through my hard drive, I was able to locate an old recording I did for the local radio station discussing Bill C-50. I have discussed Bill C-50 earlier on my weblog, but this was the original telecast, which was presented on CKLN Radio 88.1. This station caters to the ethnic community, and at that time this was a very controversial issue, and I feel that to this day it is still very important that people get out there, write to their MPs, ask them to have this bill reversed or changed, or do whatever you can, because it is really causing a problem with regards to immigration to Canada at this point, and it's been almost 2 years now, and I don't see it having any positive effect. So I wanted to play it for you in its entirety. I hope you enjoy it, and I will be back at the end of the telecast. And please excuse the quality, because this has been recorded and I'll be playing it, so I hope you understand. Anyhow, I hope you enjoy it. Thank you.
On issues that affect us in this land, the motherland, and the Caribbean. Here now is today's commentary.
Hello, my name is Nicholas Dimitrakopoulos. I'm the President and Senior Consultant at iCanada Direct Immigration Services Incorporated. I am a certified Canadian immigration consultant. Today, I would like to discuss the Conservative government's proposed changes to Canada's immigration system. The proposed changes to the Immigration and Refugee Protection Act are contained in Bill C-50. As most of us already know, Canada's immigration system has a number of shortfalls, the most obvious of which is the current backlog of applications. By making certain changes to the Act under Bill C-50, the Conservative government is hoping to solve this problem. The main concern of the Conservative government is that the current immigration backlog is close to 925,000 unprocessed cases worldwide. Yet, Bill C-50 does nothing to directly deal with this growing number. What it actually does is promote the unfair processing of applications. Since 2006, we have seen an increase in the processing times, while at the same time, we have seen an overall decrease in the number of new immigrants allowed into Canada. Prior to these changes being put forward in Bill C-50, Immigration Canada dealt with applications in the order which they were received. But under Bill C-50, the priorities will constantly be changing depending on the demands which will be established by the Minister. In other words, new cases that are considered important or a priority for the Minister will be dealt with quickly, while others will be essentially forgotten and neglected. It should be noted that currently, if somebody has their application rejected, they do have a right to appeal this decision. But once again, under Bill C-50, the Conservative government feels that the right thing to do is to eliminate the right to appeal. By doing this, the Harper government is removing the fairness and justice that one would expect a government department in Canada to have. You should be aware that in dealing with Canada's future and making changes to the Immigration Act, the Canadian government is obligated to present the bill before the Standing Committee of Citizenship and Immigration in order for it to be debated and discussed. The government was able to circumvent the role of the Standing Committee on Citizenship and Immigration in this particular case by burying Bill C-50 within the 136-page Budget Implementation Bill. By doing this, they were able to fundamentally sneak in these changes while not proposing them to Parliament. By tying them into the budget, the opposition parties were forced to either accept them or call an election. Although the government claims that these changes will not have an effect on family reunifications, in reality, there will be a serious impact on this category, since resources will be reallocated to deal with the current backlog. One of my major concerns is that the current processing times in our hemisphere, including the USA, Mexico, and the Caribbean, are among the shortest in the world. So how do they propose to help these people who have a long-standing tradition of making Canada their home? By pushing through these changes, one can't help to wonder what the motives of the Harper government are. For example, one of the proposed changes will allow the Minister of Immigration to issue instructions setting quotas on the category of person that can enter Canada, including quotas based on the country of origin. This bears a striking resemblance to the Ordering Council of 1911, which prohibited the landing of, and I quote, any immigrant belonging belonging to the Negro race. In the Chinese Exclusion Act of 1923, any immigrant of any Asiatic race was excluded. And more recently, the none is too many rule was applied to people fleeing Nazi-occupied Europe during Second World War. One would think that we have learned from our past mistakes. Giving the minister the power to decide which new immigrants are processed regardless of when their applications are filed is extremely dehumanizing, since it will be based on their ability to satisfy the needs of the Canadian job market. In essence, what we are doing is viewing immigrants as disposable commodities. Even though the government insists that these changes are necessary for us to modernize our immigration system, other high-ranking officials have stated that the Harper government is seeking to create a competitive immigration system which will quickly process skilled immigrants who can make an immediate contribution to the Canadian economy. Ever since 9/11, time and time again, we have seen the government make decisions to allocate funding and tools towards more repressive measures. For example, more than $100 million has been dedicated to arm our Canada border guards, and their priority has slowly shifted to one of an enforcement agency with regards to processing refugee claims, while at the same time sending out the message that refugee claimants are a threat to public safety. Also, the use of safety certificates against non-citizens and the implementation of the Safe Third Country Agreement between Canada and the U.S. has drastically reduced the number of asylum seekers able to make claims in Canada, resulting in increased deportations. At last count, close to 13,000 a year. This shift in Canada's immigration policy has perpetuated a racist, anti-poor, and anti-migrant agenda. In my professional opinion, which is shared by a majority of lawyers, immigration practitioners, immigration non-governmental organizations, and the general public, is that before any changes can be made, we need to fully assess the implications and possibly look for alternative solutions in order to address the current backlog. I believe that this can be accomplished by hiring more staff to deal with cases inland and overseas, and possibly streamlining the process so as to make it quicker and easier for applicants to complete the process. I believe that Bill C-50 as it stands needs to be seriously revised. People should write to their local MP to let them know how they feel about Bill C-50. A number of local community organizations have joined together to object to these changes. It is important that if we are to protect everything that we love about Canada, then we must stand up and be heard. Up to now, the Harper government has been very secretive about these changes, and whenever they are questioned, they have made a number of statements about what their intentions are. The sad truth is that expressions of current intentions give us no guarantees against future abuses of this power. After all, why were the immigration amendments included on a budget bill instead of being dealt with through separate legislation, studied by the Standing Committee on Citizenship and Immigration, and debated in public the way they should have been? Combine this with the lack of adequate information explaining the proposed changes, and what we have is widespread confusion and uncertainty. Instead of providing clear supportive materials, the minister chooses to attack critics of the amendments and claiming that we are misinformed. Even to this day, it is very difficult for the public to understand what the government is proposing to do, since the draft instructions have not been made public. But perhaps, most importantly, these proposed amendments were introduced without the normal consultation of stakeholders, which is the proper protocol. This means that these changes have not had the benefit of being discussed from a wide range of perspectives. In fact, even though the main purpose of these changes is to help resolve the existing backlog, I doubt that this will be accomplished, since they will only affect applications made after February 27, 2008. Finally, I have to say that these changes seem to be contributing towards a disturbing shift that immigration is used to meet Canadian employer needs, without taking into consideration Canada's long-standing immigration, multicultural, and humanitarian policy. We should not rely so much on temporary workers, and instead consider our workers as full participants in our society, not just disposable units that are here to fill currently available jobs. We need to recognize the need for effective and efficient family reunification policies and practices so that the immigrants can be with their families. Yet, the government, with all of its promises and intentions, is not addressing this chronic problem. That's it for today's commentary. I'm Nicholas Dimitrakopoulos of iCanada Direct, certified immigration consultant.
That's it for today's commentary. The views expressed are those of the presenter and not necessarily the views of CKLN Radio. Join us again next week at 5 p.m. for a commentary on the Black experience on CKLN 88.1 FM. that was Mr. Nicholas Dimitrakopoulos from, he's a certified Canadian immigration consultant, and he's from iCanada Direct. Yeah, iCanada Direct Immigration Services. If you want to reach him, the number to call is 647-435-3315. That's 647-435-3315. Monday, June the 30th at Harborfront, Lee Scratch Perry, the legendary Lee Scratch Perry, appears free.
Well, that was all for the radio telecast from CKLN. We hope you found it very informative and educational. Once again, we urge everybody to write to your MPs, ask them to repeal Bill C-50. It's causing havoc on the immigration system here in Canada. People are in disarray. We don't know what's going on still to this date, after it's been passed for 2 years at least. And like I says, the special edition of iCanada Direct Immigration Services, Immigration and You, was brought to you in order to inform you and educate you, which is what we're here for. If you have any questions for us, you have our number, 647-435-3315. Visit our website, www.icanadadirect.com, and you can reach us by email, info@icanadadirect.com. And we will be more than happy to address your concerns, answer your questions, in order to assist you with the immigration process with regards to coming to Canada. That's all for today in this special edition. Until next time, this session of Immigration and You is now adjourned.